Usually, when we talk about a medical diagnosis or, a scientific assessment, there is this built-in expectation of precision. It's like engineering. You break your arm, the x-ray shows that jagged white line on a black background, and the doctor just points to the screen and says, there it is. That is the fracture.
Right, yeah, it's a binary state. I mean, the bone is either fractured or it isn't.
Exactly. It's
Yeah.
clean, it's objective, and honestly, it's comforting. We desperately want to believe that science is an immovable anchor in a chaotic world.
Oh, absolutely.
But then you step into the world of civil litigation or compensation claims, regulatory enforcement, and suddenly, well, that x-ray machine is broken.
We're looking at a diagnostic and scientific landscape that is, honestly, it's just murky. And the patterns we're looking at today suggest this murkiness isn't an accident. It's practically a business model. It is the absolute definition of diagnostic muddy waters. We are raised to believe that a courtroom is a sanctuary of objective truth, a place where raw evidence is weighed evenly on the scales of justice. But the legal system relies heavily on appointed experts to interpret complex events.
Right.
The presiding officer, whether that is a judge or a magistrate, they're rarely a structural engineer, right? Or a toxicologist, or a heavy machinery mechanic. They have to rely on an appointed expert to translate the physical reality of an incident into a narrative the court can actually digest.
And what we are seeing in the documentation, which spans multiple jurisdictions, is that this reliance creates a massive structural vulnerability. Because if the system assumes the expert is a neutral conduit of scientific truth, but that expert is actually an active participant in a highly incentivized adversarial process, well, the entire foundation of the legal proceeding is compromised.
Exactly. The illusion of objective science is incredibly powerful. I mean, when an appointed expert submits a 50-page report filled with technical jargon, complex pharmacokinetic modeling, authoritative letterheads, it comes with a heavy presumption of infallibility.
Yeah, it looks bulletproof.
It does. But the documented concerns we are analyzing in this deep dive point to a profound failure in that system. Science, in these specific adversarial arenas, allegedly becomes malleable.
Let's ground this in a scenario based directly on the patterns emerging from the file. So imagine a catastrophic incident occurs. Let's say a severe infrastructure collapse involving heavy machinery at a work site.
Okay.
The immediate physical evidence is right there on the ground. The first responders are on the scene, documenting the immediate aftermath. The treating practitioners at the emergency room write down exactly what they observe in the claimant. But, fast forward 6 or 8 months,
Right.
that immediate physical reality is slowly overshadowed by dense, retrospective expert reports. And somehow, miraculously, those reports perfectly align with the financial and strategic interests of the corporate entity, the insurer, or the regulatory agency paying for them.
That is the core tension right there. The source documents reveal alleged patterns where the physical reality of an incident is methodically overwritten by what we might call a paper reality.
A paper reality.
Yes. The original contemporaneous evidence, the notes taken on the day, the photographs from the scene, the initial assessments, all of that gets sidelined. The retrospective narrative, constructed months later by the appointed expert, becomes the accepted truth, regardless of how many logical or mathematical contradictions it might contain.
It's like a restaurant where the health inspector is permanently on the restaurant's payroll. The kitchen could be completely engulfed in flames, but if the inspector's clipboard says grade A cleanliness, the state legally considers it a pristine kitchen.
That's a great way to put it.
You might think science is black and white, but what we are unpacking today shows that in the eyes of the law, science is often whatever the highest bidder needs it to be. If the system fails to verify the experts, who's actually on trial?
And that is the exact question that brings us to the structural foundation of this issue. We cannot understand the mechanism of these alleged failures without first looking at the financial architecture. We really have to follow the money to understand how a court-appointed assessor or an appointed expert is retained and funded in the first place.
So let's talk about the concept of the hired gun, because this is where the popular perception entirely breaks down. When I picture an expert witness, I imagine a brilliant, tenured professor pulled out of a university lab, someone who is completely detached from the outcome of the dispute, who just looks at the data and gives a dry, unbiased opinion.
Sure, the classic academic.
Right. But the documented patterns in civil and compensation proceedings show a starkly different reality.
A reality driven by commercial imperatives. In these proceedings, appointed experts are routinely retained and paid by just one party, And overwhelmingly, that party is a well-funded insurer, a large employer, or a regulatory agency.
Right.
This isn't a neutral, court-funded scientific inquiry where an independent body says, let's find the truth. It is a commercial transaction between a deeply pocketed institution and a private consultancy.
I want to pause on that because the implications are massive for you, the listener. If I am an expert and my entire consultancy business, my overhead, my staff's salaries, my livelihood, if all of that relies on a repeat contracts from a massive insurer or a state agency, I have a massive structural incentive to produce findings that keep those contracts coming.
Exactly. Think about the market dynamics of being an appointed expert. It is a highly lucrative field. The documents indicate a strong correlation between an assessor's findings and the commercial interests of the retaining party.
Which makes sense commercially.
It does. If you are an assessor who consistently delivers reports that expose an insurer to massive liability payouts, or if you consistently find that a regulatory agency overstepped its bounds, how often do you think that specific entity is going to retain your services again?
Probably never. I mean, they will just find someone whose scientific methodology happens to be a little more sympathetic to their balance sheet.
Precisely. The system doesn't necessarily require an expert to sit in a dark room and consciously conspire to lie. It simply requires them to view the evidence through a highly specific, incentivized lens.
A selection bias.
Exactly. Selection bias. They might emphasize certain variables while heavily discounting others. They might choose a diagnostic methodology that naturally leans toward minimizing the retaining party's liability. The system allegedly creates an unspoken structural pressure where the correct scientific finding is the one that secures the next invoice.
And this creates an overwhelming resource disparity. Let's look at this from the perspective of the respondent. Let's say you are an individual facing off against a regulatory agency or a claimant going up against a major insurer. You don't have substantial independent wealth.
Most people don't.
Right. The agency has the resources to commission multiple, highly expensive expert reports. They can flood the zone with specialized scientific authority. What are your options to fight back?
For the vast majority of people, your options are severely constrained. You are likely relying on limited legal aid, and the sources explicitly document the systemic barriers at play here. To dismantle a heavily funded, highly technical narrative, you need to hire your own competing expert.
You have to match them.
You do. You need your own toxicologist to counter their toxicologist. You need your own structural engineer to challenge their structural engineer. But if you are constrained by the financial caps of legal aid, or if you are entirely self-funded from a modest income, you simply cannot afford to match their firepower.
It is literally like showing up to a high-stakes debate where your opponent is allowed to hire the judges, write the rules, and buy the microphone.
It is a profound distortion of the adversarial legal process. I mean, the adversarial system is theoretically built on the idea of a fair fight, that both sides have equal opportunity to present evidence and challenge the other side's assertions.
In theory.
In theory. But when one side can purchase a mountain of specialized scientific authority and the other side cannot even afford a single shovel to dig through it, the truth that emerges from that process is deeply compromised. It ceases to be an inquiry into facts and becomes a test of financial endurance.
So walk me through what this actually looks like for the person on the ground. Because it's one thing to talk about structural disparities in theory, but the source documents paint a very grim picture of the reality.
Well, there are documented patterns where legal aid was initially refused or critically delayed for respondents. This leaves an individual completely defenseless at the most crucial stages of a proceeding. Imagine sitting in a hearing room. Across the table from you is the solicitor on record for a major agency or insurer. They submit a barrage of complex claims regarding liability or intricate infrastructure damage or complex mechanical failures.
And they have the paperwork to back it up.
Exactly. They have a stack of bound 50-page reports from credentialed professionals supporting every single claim. And you literally do not have the financial capacity to bring a professional into the room to say, wait a minute, the load-bearing calculations on page 4 are fundamentally flawed.
Which is terrifying, because if you can't afford the expert to formally challenge the math, the court just accepts the math as fact.
The system defaults to the only expert voice in the room. If there's no competing expert report to create a controversy of fact, the presiding officer will generally accept the appointed expert's findings as the established record.
Just by default.
Yes. The resulting judgment is practically a foregone conclusion, built entirely on an unopposed, structurally incentivized narrative.
Okay, I understand the why. The financial pressure, the repeat business model, the fact that the opposing side is starved of resources. But I am struggling to understand the how. How are these findings allegedly manufactured and submitted as fact without the whole system grinding to a halt?
Right.
I mean, if I hire a contractor to fix my roof and they tell me I need to demolish my entire house because of a loose shingle, I fire them. I don't just blindly accept it. Why doesn't the legal system spot these glaring issues?
Yeah, it brings us to the actual mechanics of the reports themselves, which is where the most alarming patterns emerge. The source materials contain extensive, documented cases where expert reports exhibited profound internal logic errors, omitted critical contemporaneous evidence, or reached conclusions that were entirely inconsistent with the claimant's own treating practitioners.
And they survive.
They survive scrutiny precisely because they are cloaked in specialized language.
Let's break down that specialized language, because the deep dive into the documents shows some wild discrepancies, particularly in highly technical fields. Let's talk about toxicology assessments. How does an expert manufacture a finding there?
The patterns regarding toxicology are particularly concerning. The documents show instances where assessments allegedly relied on boilerplate templates.
Templates?
Yes. And to understand why this matters, we have to look at how pharmacokinetics works. If you were trying to determine if someone was impaired at exactly 2:00 p.m. on a Tuesday, you need hard quantitative data. You need the raw concentration of the substance in their blood or urine, and you need to apply complex mathematical modeling to calculate the half-life and the rate of metabolization based on that specific individual's body mass and time of ingestion.
Right, you have to show the actual math. You can't just guess.
But the documented patterns suggest that in some cases, that rigorous mathematical modeling simply isn't happening. Instead, the reports utilize speculative conclusions. They rely on generic assertions of impairment pulled from boilerplate templates, without providing the underlying quantitative data required to prove it at the specific time of the incident.
Wait, hold on. You are saying they're allegedly just using copy-paste templates to say someone was impaired without actually doing the math to show how or when the impairment occurred.
That is the documented concern, yes. When you omit the raw concentration data and fail to apply proper modeling, the report ceases to be a scientific analysis. It becomes a speculative narrative wrapped in scientific formatting.
It's dressing up a guess.
Exactly. It looks like science, it has the letterhead of science, but the actual mechanism of proof is missing.
And what about physical damage assessments? Because the documents highlight documented instances where appointed experts allegedly overstated the scope of required repairs by massive multiples compared to standard industry norms. We are talking about situations where a tiny fraction of infrastructure was allegedly affected, but the expert report claims massive areas need complete replacement.
The physical damage assessments operate on a similar principle of obscured mechanics. It goes far beyond simply inflating numbers. The documents reference contradictory material specifications.
Contradictory how?
For example, an expert might cite the need for specific aggregate asphalt sizing or structural materials that entirely conflict with emergency repair standards or the original composition of the infrastructure.
Okay, explain that to me like I am 5. What does it mean to cite contradictory material specifications in the real world?
Let's use an analogy. Imagine a minor incident damages a 10-foot section of a standard wooden fence. The contemporaneous evidence, the photos taken on the day, shows a broken wooden panel.
Very simple.
Right. But 6 months later, the appointed expert submits a report stating that repairing the damage requires uprooting 50 feet of fencing and replacing it with reinforced steel, citing complex structural integrity codes that don't actually apply to that specific type of boundary. The report attributes pre-existing long-term structural wear and tear to the specific, isolated incident.
So the corporate entity or the agency essentially gets to upgrade their aging infrastructure, and they get to stick the respondent with the bill.
That is the alleged financial benefit, yes. By attributing historical degradation to a single event, the liability of the respondent is exponentially increased. And what makes this possible is a regulatory framework that allows these assessors to operate with an alarming lack of independent, peer-reviewed oversight.
This is where I have to play devil's advocate. Aren't these experts bound by professional ethics? I mean, if a toxicologist fakes a report or an engineer blatantly lies about material specifications, couldn't they lose their license? It seems like an insane risk for them to take just to please an insurer.
In theory, yes, professional bodies exist to regulate conduct. But proving intentional fraud versus a difference of professional opinion is incredibly difficult, especially when the underlying data is obscured.
Right. They can just say it was an oversight.
Exactly.
Hmm.
Furthermore, the system is fragmented. A medical board evaluates medical ethics, but they don't sit in the courtroom to evaluate how that medical opinion is being leveraged in a liability claim. There is no structural mechanism automatically double-checking the math, the half-life calculations, or the material specifications before it is entered as evidence.
And the contrast between the evidence on the day and the retrospective reports is just staggering. You have the initial first responder observations. You have the clinical notes from the practitioners actually treating the claimant in the emergency room.
Yes.
You have the initial site assessments from the day of the incident. These are contemporaneous records. And then months later, these retrospective reports are generated, and they invariably escalate the severity, the liability, and the costs.
The temporal distortion is a major red flag in the source material. The closer you are to the incident chronologically, the more minor the documented damage or impairment appears.
Because it's reality.
Yes. The treating practitioners, who have a duty of care to the patient rather than a financial contract with the insurer, record what they see. But as time passes, and as the financial stakes of the litigation become clear to the retaining party, the retrospective expert reports swell in severity.
And again, I'm struggling to understand how this survives a judge's scrutiny. If a report has glaring mathematical contradictions, or if it entirely ignores the notes from the treating doctor who was actually in the room, why doesn't the presiding officer just throw the report out?
It survives because of the presumption of expertise and the severe resource disparity we discussed earlier. A presiding officer is an expert in the application of law, not in aggregate asphalt sizing or load-bearing physics or toxicology metabolization rates.
They aren't scientists.
Right. If the report is formatted correctly, if it follows the procedural rules of submission, and if it is signed by a credentialed professional, it clears the administrative hurdle.
And crucially, because the respondent can't afford their own expert to point out the flaws.
Exactly. The presiding officer cannot act as the opposing expert. If the underfunded respondent cannot afford to hire their own toxicologist to say, "Your Honor, the pharmacokinetic modeling here is completely fabricated," the presiding officer has very little choice but to accept the appointed expert's document as the factual record.
It's the paper reality taking over. If the paper says the sky is green and the respondent can't afford the specialized scientist required to prove it's blue, the court legally decrees the sky is green.
That is the exact mechanism of the alleged failure. And this highlights the urgent need for what the sources refer to as evidence integrity protocols. Specifically, the necessity for a national register of expert witnesses with mandatory disclosure of their outcomes data.
Mandatory disclosure of outcomes data, meaning an expert would have to publicly show their track record.
Yes. Currently, an expert's history is fragmented across hundreds of isolated case files. If an appointed expert has provided 50 reports for a specific regulatory agency, and 49 of them miraculously found maximum liability in favor of that agency, that pattern of bias would be immediately visible under a mandatory disclosure regime.
But right now, that data is hidden.
Completely hidden. The presiding officer only sees the single report in front of them, not the overarching pattern of incentivized findings.
Which sets up the next massive hurdle. If you are the person staring down the barrel of one of these manufacturer findings, you know the math is wrong. You know the report contradicts the reality of what happened. What do you actually do? Who holds these experts accountable?
That is where the system reveals its most formidable barriers. This section of our deep dive explores the aftermath of an allegedly flawed finding. What happens when a party attempts to challenge the expert testimony through the proper channels? The sources suggest that the available complaint pathways overwhelmingly fail.
The systemic shielding here is genuinely hard to wrap your head around. Let's walk through the complaint pathways. If I spot a massive error in an appointed expert's report, say they claim property damage that clearly predated the incident by 5 years, I should be able to just point that out to a regulatory body or an administrative tribunal, right? I show them the proof, and they fix it.
Well, in theory, administrative tribunals and regulatory bodies exist to hear those exact complaints. But the documented patterns reveal a glaring absence of effective oversight. Because there is no mandatory disclosure regime, you cannot prove systemic bias. You can only argue about the specific technical details of your single, isolated case.
And we are back to the resource disparity.
Precisely. The administrative bodies designed to hear these complaints are often not equipped to overrule complex scientific testimony without a competing expert retort. You are walking into a tribunal saying, the expert's math is wrong. The tribunal responds, we are not mathematicians. Where is your expert report proving it is wrong?
Wow.
And if you can't afford one, the complaint pathway hits a brick wall.
It's an endless, self-defeating loop. But the source documents show it gets even darker. They highlight documented patterns showing that attempts to demand the underlying data, the actual raw proof behind the expert's claims, are met with fierce resistance.
Oh, extreme resistance.
We are talking about basic foundational evidence, chain of custody logs for toxicology samples, raw video footage from the site, contemporaneous field notes. The suppression rates for these documents allegedly exceed 90% in some of the documented instances.
What is deeply concerning here is the mechanism of that suppression. Why would an agency or an insurer fight so hard to withhold raw video footage or a chain of custody log?
Because the raw data would prove the expert report is flawed.
That is the logical inference. But the legal system allegedly facilitates this suppression by prioritizing procedural finality over scientific accuracy.
Procedural finality. Translate that for me.
It means the system cares more about stamping a case closed and moving on to the next file than it does about ensuring the underlying science is flawless. Once an expert report is accepted into the record, the bureaucratic momentum shifts entirely toward resolving the case, issuing the judgment, and enforcing the penalty.
So they just want it off their desk.
Yes, reopening the evidentiary phase to scrutinize chain of custody logs disrupts that momentum.
I want to talk about model litigant rules. Because when I was reading through the sources, this concept completely blew my mind. Government and corporate entities are supposedly bound by specific guidelines that dictate they must act honestly, fairly, and with the highest ethical standards during proceedings. They aren't supposed to play dirty or hide evidence.
That is the intended function of model litigant rules. They are designed to acknowledge the vast power imbalance between the state or a massive corporation and an individual citizen.
Sure.
However, the sources document a severe pattern of concern regarding how these rules are applied or ignored in reality.
The documents show that proceedings and aggressive enforcement actions allegedly escalate even after severe discrepancies in the expert evidence have been formally flagged by the respondent.
Yes. Let's walk through the mechanics of that escalation. Imagine you, as the respondent, manage to definitively prove a glaring flaw. You explicitly tell the agency, look, the expert's report has a massive mathematical error. The dates of the alleged incident don't align with the claimant's employment records, and the underlying video evidence is missing.
And the agency's response? Do they pause the proceeding to investigate?
According to the documented patterns, the response is often to push forward aggressively. The momentum of the enforcement machinery does not pause for factual correction once the expert report has provided the necessary legal cover. The agency might issue threats of asset seizure or apply for garnish orders.
Let's explain garnish orders for anyone who hasn't had the displeasure of dealing with one. They literally bypass you entirely. The agency goes straight to your employer or your bank and legally forces them to drain your paycheck or your savings account to pay the alleged debt before you even get your day in a fair court. They use the bureaucracy as a weapon to starve you out.
Exactly. And this raises an incredibly important question about the nature of justice and reality. If a finding is manufactured, if the science is fundamentally flawed, but the state enforces the penalty anyway, the truth of the document becomes irrelevant.
Because the damage is done.
The enforcement makes the paper reality real. If they seize your assets based on a flawed report, the damage to your life is absolute, regardless of what the contemporaneous evidence said.
The process itself becomes the punishment. If the regulatory agency simply ignores the discrepancies, stonewalls the complaint pathways, and sends in the debt collectors, the expert's flawed report essentially becomes a self-fulfilling prophecy.
Consider the psychological and financial toll on the individual trapped in this loop. The system allegedly uses the sheer weight of enforcement to coerce settlements. If you are facing imminent asset seizure, if your wages are about to be garnished based on a 50-page report you can't afford to formally challenge, you might agree to a settlement just to survive.
You tap out.
You tap out. And by settling, you permanently seal the flawed expert report into the unchallengeable legal record. The insurer or the agency gets their win, the expert gets their invoice paid and keeps their pristine track record, and the systemic failure is buried under a confidential settlement agreement.
Put yourself in those shoes for a second. Imagine living this. You know the facts, you were there on the day. You know the incident was minor or the liability wasn't yours. But this paper reality, funded by limitless resources, written by a credentialed assessor who relies on the agency for their livelihood, and protected by impenetrable bureaucratic walls, is slowly crushing your actual physical reality.
It's devastating.
And there is no referee willing to blow the whistle.
This is exactly why the source documents insist that these systemic issues cannot be solved by simply hoping for better behavior. We cannot rely on the ethical compass of individual practitioners or expect agencies to suddenly start adhering strictly to model litigant rules out of the goodness of their hearts.
Right, you can't just ask them nicely.
No, the structural incentives are too powerful, the lack of accountability is too deeply entrenched.
Which brings us to the solutions. Because we aren't just diagnosing a critically broken system today, the sources point toward very specific, hard structural remedies. We need to overhaul the invisible architecture of this system. We need to fix the X-ray machine.
The documents outline 3 specific reform pillars necessary to dismantle these alleged patterns of corruption and bias. These are not minor procedural tweaks, they are foundational shifts. The first is the creation of a Judicial Integrity Commission.
Let's expand on that. What does a Judicial Integrity Commission actually do? We aren't just talking about a passive review board that rubber stamps complaints, right?
No, we are talking about an active, independent oversight body with the statutory power to mandate exactly how courts weigh and verify expert evidence. A commission that demands rigorous mathematical proof, not just a credentialed signature.
So they would actually check the homework.
Exactly. If a toxicology report is submitted, the commission would ensure that the underlying pharmacokinetic data is present and peer-reviewed before it can be entered into the evidentiary record. It removes the burden from the underfunded respondent to spot the scientific flaws and places it on the system to verify the science proactively.
The second pillar addresses the secrecy, which seems to be the linchpin of the whole problem. Evidence integrity protocols.
This is crucial, establishing a national expert register with strict mandatory disclosure requirements. This means pulling the data out of isolated case files and making it public.
Dragging it into the light.
Yes. If an expert witness has a historical track record of overwhelmingly favoring the retaining party, say, finding in favor of an insurer in 95% of cases over a 10-year period, that outcomes data must be disclosed to the presiding officer and the respondent at the beginning of the proceeding.
You can't hide a pattern of bias if every single report you've ever written is mapped out on a public spreadsheet.
Exactly. It forces the court to confront the commercial reality of the expert's practice. It shatters the illusion of the neutral, detached professor.
And the third pillar tackles the financial asymmetry directly. Legal aid reform.
If the adversarial system is going to rely on a clash of experts to find the truth, then both sides must be armed. Ensuring that claimants and respondents without vast personal wealth can actually afford independent expert rebuttal is fundamental.
Because right now, it's not an adversarial system, it's an unopposed narrative.
Leveling the playing field through expanded legal aid, specifically earmarked for expert retention, is the only way to test the veracity of the heavily funded reports. If an insurer knows that their retained expert will inevitably face rigorous cross-examination from an equally qualified, legally aided expert on the other side, the incentive to manufacture findings diminishes drastically.
The risk of exposure becomes too high.
It fundamentally changes the financial and regulatory incentives. You can't just buy the narrative if the other side has the resources to scientifically dismantle it, line by line, in front of an active integrity commission.
If we connect this back to the beginning of our discussion, the goal of these 3 pillars is to return to a system where evidence is binary, verifiable, and objective. To ensure that science in the courtroom is a tool for uncovering the truth, rather than a commodity to be purchased, manipulated, and weaponized against the vulnerable.
That is the ultimate goal of these proposed structural reforms.
We started today by looking at the blind spot in the courtroom. The deeply ingrained assumption that the person with the longest CV, the most complex terminology, and the most authoritative letterhead is inherently telling the truth. But when the structures of funding and accountability are hidden, when the mechanics of the science are obscured by bureaucracy and financial disparity, that blind trust is dangerous. It overwrites reality. So the next time you hear the phrase experts agree in a high-stakes dispute, or you see a heavily funded narrative pushing forward with that resistance, I want you to critically question the invisible architectures of authority behind that agreement. Because as the sources make chillingly clear, an expert who cannot be cross-examined on their history is not an expert. They are a weapon.